or 3 different words other than the one word. They don't make it easy, but that's just the way it is. So like real estate could be called realty, all right? It could be real property. It could be a whole bunch of different names, but they do have specific, they are specific in what they mean. So, so anything that we will be discussing, half the time they have 2 or 3 different words, but mean the same thing. Okay, so real estate. Okay, to have real estate, you have what they call a bundle of rights. These earrings are driving me insane. Okay. So I look at it as a bunch of balloons, and each balloon represents something. Okay, so to make life easy to remember between my balloon and my acronyms, okay, in this case the acronym is PUDEE, or it could be PUTEE, putty or putty. All right, so the one balloon could be possession. Another balloon is the use of the property. A third balloon is the disposition. And remember I said there's different words for different things. So disposition, alienation, transferability, all mean the same thing, okay? Then we have enjoyment, and then we have exclusion. Those are the main bundle of legal rights, okay? So when I own property, I have a bundle of balloons that give me legal rights to possessing the property, okay? The other ones are, I can build on it, I can grant easements, I can put a mortgage on the property, okay? I can restrict the use of the property, I can will it, I can devise it, which means I can put it in a will, all right? I can give a license to somebody to come on my property, I can rent or lease my property, I can refuse to sell it, I can sell it, I can make sure that nobody comes on my property, I can give away my property, or I can abandon it, okay? So those are the additional types of bundle of rights, okay? But the main ones are possession, use, again, depending if you're going to do the D, it's disposition, if you're going to do the T, it's transferability, whatever works for you, easier to remember, and then enjoyment and exclusion. Those are the main legal bundle legal of rights, okay? So what is the description of land? Okay, so because we have to start out with the description of land in order to figure everything else out. So in this case here, land refers to the earth's surface, including water and anything that is permanently attached by nature only, okay? So if there's trees attached by nature, okay, then that's land. And the key here is that it extends all the way up to the universe, end of the universe, wherever that is, and then all the way down to the center of the earth, okay? And it includes anything above as well as below. So the below could be what they call subsurface rights and water rights, and then up above is called air rights. For me, the easiest way to remember it was heaven to hell, okay? So I own from heaven to hell, and anything in between belongs to me. Now, of course, there are restrictions and things of that nature, but if you start out with that premise and you can remember that premise, it makes everything further down the line easier to remember. So heaven to hell with anything that's attached by nature or anything that's above or below. So from there now, we're going to go to real property, okay? So the word real property includes land. It includes the improvements of the land, meaning anything that has been man-made, that has been attached to the land. And then as a result of that, I automatically get my bundle of rights, okay? So improvements is anything that is man-made that has been attached to the property, okay, then now becomes real property, all right? So Real estate or real estate is known as real estate, real property, and realty. And in the state exam, I can tell you that they interchange any of these words, and that is why you need to know these words. Okay, so the real estate, real property, or realty is the land and the rights, such as easements, rents, profits, and all attachments. Okay, personal property is everything else that does not meet that definition. Okay, then you also have all of the man-made improvements, right? So you have the air rights, because we can theoretically sell it to a billboard, the air rights, okay? Of course, they have the right, of course, the government has the right to limit the height because of the air traffic, but basically we own the rights, okay? And then we also own the rights which are underneath. So if we were in Texas, theoretically, we could have crude oil, gold, Texas tea, you know, and or we can have water rights. Now, the water rights that are under the water is different than the water rights that are alongside the property, like a river, okay? So the water rights that is under the property would be more for what they would call potable water or drinking water or well water. Okay, so that would be one version of it. And the other version of it, which we're going to be talking in a few seconds here, is if we have a lake or a river or the ocean, then we have certain rights to that water. Okay, but when we're talking about here describing real estate, we're talking about the water that's underneath underneath the property, and therefore typically that would be water, drinking water or well water. Okay, so a property, we're back to that again, a property is a thing or a right that has a monetary value and is capable of transfer. That right there is the key word. So it has to have a monetary value, okay? And we are able to transfer it from one person to another person, okay? So therefore, real property is not movable, okay? Realty, real property, real estate is not movable. If we're talking about personal property, then that means we can move it. We can take it with us. We can put it elsewhere, okay? So personal property is something that A, is movable, B, belongs to us and goes with us wherever we go, okay? So if we were talking about farmland, that would be, in that description, it would be a tractor, okay? That's not me, is it? No, okay. So it would be a tractor. Or if we're talking about a regular suburban house, it could be our car, all right? It could also be a shed in the back of the house, all right? Depending on how the shed is set up in the backyard, okay? If it's just sitting on top of something and it's not securely attached, then that could be potentially movable, all right? But if it is secured to a foundation and all of that, then that is not movable, therefore it would be classified as real property, okay? So when we're talking about personal property, it is automatically excluded from the sale if we have a listing, all right? Unless it was specifically included in the listing to be included as part of the sale, okay? Are we good with that so far?
Yes.
Good, okay. So that is property, that is real estate. Whoops, sorry. So what are our rights to the property, or our bundle of rights again, okay? It gives us the absolute ownership of that particular piece of parcel, okay, or piece of land. So therefore, if it's raw land, well, we can certainly build on it, okay? If it's land or anything, any improvements upon the land, we can pass it by will. And the word pass by will is devise, D-E-V-I-S-E. So it's devise by will. We can lease it or rent it. We can put a mortgage on there, We can limit the use, or basically no trespassing, no hunting on this property. We can choose to sell it, or we could choose not to sell it. We can grant a license or an easement. So a license is, I am giving you license to come on my property because I'm asking you to fix my electric on my property. That would be a license, okay? So I'm allowing you to come onto my property. If I have kids, which I don't, but if I had kids, and I had a babysitter coming to take care of my kids, well, I have cats, so they can come take care of my cats. Then I'm giving them a license to come on my property to take care of my cats. An easement is something different. It's actually put into a deed, and it's allowing another person forever and ever to go on my property to access their property. Now, again, there's different types, and we'll talk about that in the future, but that's basically what that means. To mine, drill, or encumber the land. Again, to mine and drill. Again, if we have gold underneath our property, diamonds, hopefully, oil, gas, or whatever, we can allow people to dig and drill and do all of that kind of stuff, and then we could potentially get royalties on that as well if we needed to. Okay, so this is basically my heaven to hell right here. So we have heaven up here. We've got the public and private air rights. Okay, then we have the private air rights, which is pretty much ours. Then we have the earth's surface. We have the subsurface, and then the center of the earth. So the exam is probably going to ask you about what is the description of land. So you need to know it's the earth's surface, anything above, anything below, and naturally, keyword, naturally attached. Okay, so that is the key word. If we're talking about land specifically, we are talking, the other word that they use is a parcel of land. Okay, so parcel is just a piece of property. Okay. Now, as far as water rights are concerned, so here we have different types of water rights. So if you're following in the book, it's on page 85. Okay, so on page, so water rights, you have what they call littoral rights, which refers to a lake, and I'll get into that. I think I'll get into that later. Yeah, okay. So we have what they call littoral rights. We have riparian rights. We have rights where we can gain land by nature, which is known as accretion, alluvion, reliction. The loss of land, we at the Jersey Shore know all about erosion. And then we have avulsion. And then we have front foot. Okay, so if we go down the line here, all of the navigable waters is owned by the state. Originally, it was owned by the Crown when the British owned our area, but now it's owned by the United. What am I doing here? Okay, it's owned by the state. So anything that's navigable is owned by the state or the government, the U.S. Okay, so littoral rights is something that's bordering the frontage of the ocean, sea, or lake. The easiest way for me to remember that word, okay, is that it has an L, therefore it equals lake. All right, that was the easiest way for me to remember. So a littoral right means it's on a lake, and then I can remember after that sea and ocean, and that was easy enough for me to remember. Riparian rights is when you have flowing or not or navigable water. You can have non-navigable water like a creek, or as I call them, fingerlings. Okay, so those are called riparian rights. And these kind of waters in New Jersey is called tidal waters because the water comes in with the tide and goes out with the tide. Okay, so riparian, again, I remembered the R, so therefore that equals river. So river, riparian, that's how I smushed those two together to remember. Navigable water in New Jersey is owned by the state. Now you can get rights that are sold or actually leased, okay? Or you can get a grant. This machine is, okay. All right, so grants go with the deed or belong to the property. New Jersey no longer gives out grants, okay? They are now leasing rights to the water, and we'll get into that a little bit further down the line. The underground water, as I mentioned before, is based on well water, and it's owned by the landowner. And they can use it for their own use, meaning they can, depending on how it's set up, it's either well water because that's what they're drinking, okay, and washing their clothes and bathing and all of that, or it could be well water that is being used as irrigation for their landscaping, okay? You cannot take that water and pump it and sell it off to somebody else, okay? That we are not allowed to do. So, littoral, okay, just to give you a visual here. In this case, anything, whether it's the ocean, the sea, or the lake, you own it up to the high water mark, okay? So everything up until where the high water mark, that land belongs to you. A riparian right, on the other hand, has two different ways of ownership. So the first ownership, where the water is tidal and it's moving back and forth, and you can actually have boats on that property, then you just own to the edge of the water, okay? And it could get more complex, but let's right now just call it this way. So it goes to the edge of the water, okay? The water itself in the middle is owned by the government, the US, all right? If we have a brook that you cannot have a regular boat on it, I mean, you can have a canoe, you can have a kayak or something along those lines, but it's really not a navigable water, meaning no ships, no big motor boats, no, you know, then in that case, you would be owning it to the middle of the brook. A brook, a creek, a fingerling, I don't know what other words I can think of for that. But then the bottom line, it's not tidal. It doesn't go in and out with the tide, and it cannot have a boat on there, okay? Then you own to the middle of the brook. And that's important because when we start talking about land descriptions, then that's going to make a difference. If they're talking to you about a piece of property that has a brook on it, then you need to know you have to go into the middle of the brook. If it's a navigable water or a tidal water, then you know that you're only going to the edge of the water. Okay, that is the difference. Okay, are we good so far? All right. So here in your book, you have this right here. So you have lot A and lot B. You own it into the middle, and then here you own it to the edge of the water. Okay, now to the edge of the water can also depend on the kind of right that you have. You can have a granted riparian right, okay, where it would show up to what point in the river. Again, here we're pretending that this is a bulkhead, but if there was no bulk, I mean, if you have a bulkhead, you only own up to the bulkhead. You may have leased rights to put up a dock or something like that, okay? You really don't need to know this for the state. This is not state, this is real life. So if it's a bulkhead, it's a river and it's a bulkhead, you own up to the bulkhead, and depending whether you have a leased right, you may have the right to put a dock or something on here, but then you're leasing that right from New Jersey. Okay, but you're actually owning it only up to the bulkhead, okay? If you have a grant, okay, and that goes with the property, then depending on the kind of waterway that we're talking about, so if it's an embankment, okay, if it's like a little embankment and then the river is over here, then in that case, you may, you would, I believe you own, again, in that case, up to the high water, I think they call it the high water mean tide, okay? So you actually own that land, but no matter what you do in New Jersey when it comes to water or anything that's along the water, you're going to have to talk and get permits from the DEP, the EPA, and all these CAFRAs and CADRAs and all of that, okay? So having said all of that, erase all of that because that's real life. Let's go back to the book for the exam. All right. If it's a non-navigable stream, if it's a brook, all right, you own to the middle of the brook, and that's your property. If it's a navigable water, and therefore the water is owned by the public or by the U.S. government, then you own only up to the edge. All right, and both of these are called riparian rights. You have the riparian right to the water. Any questions? Okay. All right. So the next thing that we need to know is the different ways that we can gain land or lose land. Okay. So accession is gaining land or title to the land by natural, or it could be man-made causes. So that's accession. All right. So it could be by natural, meaning the wind and the water and the rain is adding on to the land. Okay. Accretion is actually via the wind and the water. So the key word here, and this is what you have to remember, because again, it's all sorts of different words meaning the same thing. Okay. It's the gradual addition of alluvial, keyword, alluvial soil deposited by wind or water. And if you look on your page, oh, they don't have it here. Yeah, they do. Where it says accretion on page 86, they call it also alluvion, I-O-N, alluvion. Okay, so you might get the word accretion, you might get alluvial soil, you might get alluvion. Okay, so anything along those lines, that is where it's the gradual addition. Reliction, again, if you look at if you remember the L, then you know it's a lake, or it's easier to remember that it's a lake, okay? And therefore, it's when the lake dries up, your land is growing, okay? So I can't say this happens by the sea and the ocean, so that's why I'm not using that example, even though they use the littoral aspect for sea, ocean, and lake. So if I just put the two together, it's easier for me to remember when the state exam comes along. So reliction has an L, therefore it means that the land is drying by the lake, okay? Or the lake is drying and therefore I'm gaining land. Avulsion, again, for ease of remembering, if you have V, you see that it says V, it has a V in there, it means violent, okay? So avulsion is a violent loss of land. So typically it would be if we had a tsunami or we had a hurricane and the road goes down because it was undermined or anything like that. Erosion, again, and New Jersey, at the Jersey Shore, it's not a gradual loss of land, but that's really what that means. It's a gradual loss of land over time, okay? So really what happens at the Jersey Shore is avulsion more so than erosion. So when they say the Jersey Shore, you know, the shore is eroding, the answer really is more it's whatever it's doing, avulling, okay? So, but again, just to go over, avulsion, it has a V in it, so think of it as a violent loss of land. Erosion, don't think of the Jersey Shore. Erosion is slow loss of land, okay? Alienation, okay? Now, alienation, you're going to see comes up in many, many, many different ways. And basically what it means is that a tenant or a person is leaving a fixture behind. So in this case, if we have well water, in this case, we usually would have a water filtration system. So we have alienated ourselves from the water filtration system because we're leaving it behind, okay? So it has now become a fixture, which we'll be discussing further down, but it has now become a fixture. It's a part of the property, okay? So we have alienated ourselves because we sold the property. So we're leaving that behind. So that's what alienation means. All right. Any questions so far? Okay. Moving along. So accretion, here's two pictures. They didn't have any pictures in the book. So here are two pictures, okay? So the old disappearing primary parcel of boundary, it started here and now it's being gained over by the river. We're getting land on here. In this case here, the way the river is flowing, we're adding land to this little original island. So that's addition of land. Accretion is addition, okay? Reliction is where the water recedes from the land. So here in this case, whoops, what happened there? So here in this case, they're showing how it was originally, but now the water is receding. I don't know why rivers recede, but anyway, it's receding. So in this case here, okay, all of this is added land that they didn't have. And what happens is then their property line ends up where their new land is formed. Okay, so where in reliction, the shaded area is now the new land that's now their new property line, and they now have the right to use that. Alluvion, accretion by alluvion or alluvial soil is again alluvial soil that's gradually added. So again, we have an old shore here and the river is adding because it's going on either side. Or again, in this version here, we're adding water. And so now we have a new property line, which is over here. Okay, are we all okay with this so far? All righty. Erosion is basically where the land is going away and then the property line is also changing because the land is going away. Okay, so if you're losing land, if the land is eroding, then you're also losing your property line. Your property line is getting shorter and shorter. Okay, avulsion again is to a sudden change, okay, or a violent change. This is a better picture for avulsion. This is actually what avulsion is. So as you can see, it's eroding underneath, it's falling down, and that's the end of that. Okay, beach rights, property and water. Okay, the ancient English law meant that the crown had the power over all the navigable waters. But then as we became freed and we became the United States, then it basically stated that the water has now become a public trust doctrine. And basically the water's held in trust on behalf of the public, on behalf of the United States public. And what happened there for a while, there were some lawsuits about is the beach really public or can it be privately owned? And the answer is it is public and it cannot be privately owned, even though they say that it is privately owned. They're only owning it once again, up to a certain point, and then the rest belongs to the public. So like as an example, in the beach clubs in Seabright and Monmouth Beach and all of that, basically, I believe it's I think it's called the high mean water tide. So they own up until that point. So at high tide, theoretically, you can't walk across their land. And once the tide goes down, everything else belongs to the public and you can walk across and they can't bitch and moan. And that's basically what the 1984 lawsuit was about. Okay, real property versus personal property. So what did I say about personal property before? Does anybody remember?
It's movable.
It's movable, exactly. Okay, so personal property is also known as chattels. Okay, so in the exam, if you see chattels, you know they are talking about personal property. Okay, I thought it was called cattles, but it's actually chattels. So I always called them cattles, but until somebody corrected me. So any chattel, any kind of chattel has to be transferred by a bill of sale if you're selling any personal property, okay? So if you're selling anything over $500 of your personal property, then you need to write up a bill of sale, okay? Now that means even on everyday stuff, okay? So anything that doesn't fit the definition of real property, okay, is then considered personal property. So that will also include annual crops. So if I am a farmer, the annual crops are known as emblements. You do need to know that word. And so if I am sowing seeds, all right, and then I'm cultivating it, and I'm cultivating the corn or wheat or whatever it is, okay, then when it's time for me to harvest it, and let's just say I sold that land, I have the right, of course, as with everything, it has to be in writing, but when it's time for me to harvest that corn or wheat or whatever it is that I'm growing, I have the right to go back and harvest it because it's considered personal property. And the reason it's considered personal property is because I hand planted everything and I hand took care of it. Well, maybe with the tractor, but I basically took care of it. It was not put there by nature. All right, that's the difference. Okay, it was my human toil that made these things grow, and so therefore they are personal property, and I am able to go back and harvest the items. Trees are considered real property, okay, because they're there by nature, they were there by nature, and therefore they are considered real property. Now, having said that, in my next picture, okay, well, it's not in my next picture. So the other way, okay, you guys, I sent you a blank acronym page. If you printed it out, great. If not, you might want to write this down and then put it on your acronym page that I sent you through Google. So a fixture is considered a personal property that has been permanently attached to land or a building. Okay, you can have tenant or you can have trade fixtures or a combination of both. And the way you want to figure out if it is a fixture and not personal property is through this acronym. So you have, it could be Maria, it could be Marie, whatever works for you. Again, for me, I like to have a full name, so it's Maria. So it's the method of attachment, but they're going to use the word annexation. Okay, so it's the method of annexation. All right, it's the adaptation of the article to the real estate. It's the relationship of the parties. How was their relationship? Was it agreed upon, not agreed upon? It was the intention of how they are attaching the property. Was the intention to leave it there forever? Okay, or was the intention that I'm putting it up there as long as I'm living here, but when I leave, I'm taking it with me? And the last part is the article. Okay, now the other version is Marie without the A, without the article. Okay, so it's the method of annexation, which means attachment. It's the adaptation of the article to the real estate. How are they using it? It's the relationship of how the parties agreed to it. It was the intention of what did they intend to do with it, and what kind of an article is it, okay, or a piece of property. So again, we heard earlier, we have chattel. So chattel is considered tangible personal property, and it could be financed by a security agreement, and it could be called a chattel mortgage. Okay, so a chattel mortgage is a personal mortgage, and the perfect example of that is if you are buying furniture and you're financing that furniture. Okay, because furniture is personal property, you're financing it, so theoretically then that would be considered chattel mortgage. That's not what they're going to call it, but that in essence is what it is. All right, real property is financed by a mortgage. It's a plain old mortgage, okay? The bill of sale, as I stated, transfers any personal property that's over $500, okay? Now, real property can transfer by a deed or by a lease, okay? So when we're saying we're transferring by a deed, typically that means we have sold the property. If we're transferring it by a lease, we're allowing the people to come onto the property, have possession of the property while they're paying rent, all right? But that does not mean that they own it, okay? And tax laws can make specific distinctions. So the property cycle. So remember we said that trees are real property, right? When I cut down the trees and I've made them into logs, and then I cut them down even further because I want to use them as a, for my fireplace, they have now become what they originally were real property. They have now become personal property because I can use them, I can pick them up and leave with them, okay? But if instead of making it into firewood, I've kept them as logs and I turned around and I built a log cabin, they have now become once again real estate or real property, okay? So again, how is it attached? It's attached permanently, so now it becomes real estate, okay? Good so far? All right, personal property. Remember we talked about never on a Sunday?
Mm-hmm.
Okay, so here's the mobile home, which is considered personal property, okay, as long as it remains movable. So if you can physically see, without moving things around, you can physically see the tires, okay, and you can physically see that triangular thing that attaches to a hitch, okay, and there is no permanent foundation where it's not attached on top of concrete or something, then it's considered personal property. But if there's a foundation, a concrete foundation, and they've hidden all of the tires, and that triangular thing, the hitch thing, is no longer there, then now it has become a fixture. So now it has become real estate, okay? However, because it's a motor home or a mobile home, it would have to go by the Department of Motor Vehicles rules and regulations. So basically what that means is we cannot sell it on a Sunday. So basically the contract cannot be written on a Sunday. We can certainly show the property on a Sunday, but we just cannot write a contract on a Sunday, all right? And if we did something wrong in writing up the contract offer or whatever the case may be, then we are sanctioned by the New Jersey law, New Jersey license law, or the New Jersey Real Estate Commission law, all right? So if we didn't do something right about the contract, that comes under the New Jersey license law, or it comes under the Real Estate Commission law, okay? But the sale of the property, the sale of the motor home, comes under the jurisdiction of the motor vehicle. All right, so personal property regarding plantings, okay? So personal property regarding plantings. Perennial plantings such as trees, shrubs, natural growth, no regular annual cultivation. That's the key word. No regular annual cultivation is part of the land. It is considered real property, okay? Annual plantings, anything that is produced by man's labor, okay, is called emblements, and that is personal property, okay? Now, so again, as I stated, if we were growing corn or wheat or something like that, and we sold the property, okay, once again, everything has to be in writing, so therefore it would be in the contract stating that when it is time to harvest my corn or whatever it is, I will be coming back, meaning I will be coming back on top of this land to harvest my corn, my wheat, my whatever it is, blueberries, blackberries, whatever it is, okay? So that is my right to that harvest, okay? Because it's a yearly thing. Now, having said that, a as you can see, it says perennial plantings, trees, shrubs, natural growth, no regular annual cultivation is part of the land, okay? And annual plantings, we stated again, is grain, corn, etc. Landscaping, okay, can be taken into two directions, all right? Most people leave the landscaping behind, you know, the trees that they put in there, those beautiful fingered trees, you know, and any kind of bulbs or anything like that, okay? They leave that behind. They're not going to take it with them. But they can if they wanted to. Again, if they wanted to, they can specify what they're going to take with them because it is cultivated by man's labor. All right. So as an example, I had two different people that the one lady wanted these iris bulbs that were given to her by her great grandmother or grandmother, and they were antique iris bulbs, okay, and that she was going to come back and she was going to dig up these iris bulbs, all right. So you have to, if that is the case, all right, you have to make sure you put that in the contract, that is what she's going to do. You need to put that in the listing agreement. So when I went to list her house, all right, and she was telling me this, I said, okay, that's fine. I said, but I'm going to have to put it in the listing agreement so that everybody is aware that this is what you're going to do. And I'm also going to take a photograph of where these bulbs are. All right, so in this case, at this time, they were not blooming, so I just showed dirt. But I had to give some sort of a reference point where it was, you know, in relationship to the house. So again, they are allowed to do that because it is produced by man's labor. The other thing is, I had another gentleman that had just put in some sort of a fancy schmancy Japanese tree that cost him thousands of dollars. And so he said the same thing to me, you know, when he sells, this particular tree is coming with him. So again, what I did, the same exact thing. I wrote it into the listing agreement, all right? It has to be notified. It has to be put into the agent notes. I wouldn't necessarily put it into the public notes because that might turn people off, all right? So if you just put that aspect of it into the agent notes, then this way the agent, while they're walking around the house, they can understand that. And then again, I took a picture of it just so that we all knew which tree we are talking about. All right, are we good? Okay, so these are the different things regarding real property or real estate, okay? So we have sky rights, okay? We have tangible property right here. We have water rights. We have personal property, the dog and the car. We have easements and right-of-ways, and we have chattel, which is also personal property, okay? And we also have underground ownership of whatever is underground, okay? So now what's going on here? Okay, that can't be it, is it? Okay, all right, so that's the end of that chapter. That went pretty fast. Any questions? Okay, little crickets, no questions?
No. No.
No, we're doing good. All right. So, all right, so that takes care of that. So now we're going to go to chapter 6. Okay. All right, where's my chapter 6? Okay, there it is. Now share, chapter 6, share. Actually, I wanted, I'm back to chapter 5 here for a moment. And I want to just see if we did all of the words in the key terms. And yes, we did. We took care of, oh no, we didn't. There's one word we did not take care of, which is front foot, okay? So front foot is when you're looking on the tax map or when somebody's talking about property, they're going to say, well, the property is 50 by 100, okay? So the front foot in this example is 50, all right? So when you're looking at the tax records and it says it says 75 by 175, the front foot is 75, okay? And the reason they're calling that the front foot is because that is the land that is abutting the street, okay? So the land that is abutting the street, the beginning of your property, is the front footage, and it's always the first number. Okay, so if you see a property that's 30 by 100, you know that the front of the property is 30 feet. Okay, and that is also if the town decides to put any improvements on that street, they will charge you based on your front foot. So in my 30 by 100, it will be based on 30 foot of what you own on that particular street. Okay, now, having said that, there is also what is called water frontage. All right, so everybody wants to know the size of the property. That goes without saying. But if you're selling waterfront property and you have somebody who has a boat, all right, they want to know what the waterfront frontage is, or the water frontage is. So it's highly recommended that when you're selling water property, that you measure the property. You can see it on a survey. You measure what that property is along the water, so that this way you'll know how much water they have available. Okay, and then you'll go into more detail, because if this person that has a boat is actually a sailboat, then you know that they have to have deep water because of the keel. All right, that's the bottom of the boat, I think, yeah. So they need to have a lot of water to be able to get the bottom of their boat in. So when selling waterfront, you need to know the waterfront frontage or footage, okay? And then eventually you'll also need to know how deep the water is and what you're allowed to have. Is there a dock? Is there not a dock? And so forth. All right, so that's front foot. Hereditament, the word hereditament is basically the property that you have inherited. Okay, so if you're on page 83 where all the words are, okay, hereditament is what you have inherited, the property that you have inherited. The other word that's in here is incorporeal versus corporeal. So corporeal means I can touch it, it's tangible. Okay, so corporeal and tangible go hand in hand, and incorporeal and intangible go hand in hand in that they cannot be touched. So an example of what cannot be touched would be stock. We buy stock now. It used to be you would get stock certificates. I don't think you get stock certificates nowadays, so it's not tangible. Or a franchise or a business name is not necessarily tangible, all right? So that would be incorporeal. All right, and I think we've gone through all of the words. All right, so what does devise mean?
Leave by will.
Yes. I'm sorry?
Leave by will.
Yes, yes. Left by will, correct. Okay, oh, to get back to Google for a second, you will have gotten a link to Quizlets, a vocabulary on Quizlets, all right? That was one of my students that actually did all of those. It's a flashcard. I don't know what flashcards are. I've never used them in my life. So, but it's a flashcard vocabulary Quizlet, and you have a link on Google for that. So if you are a flashcard person, this should help you. I have no idea what it is. I'm sorry to admit stupidity on this, but it is what it is. So she did it on this book with all of the key terms and other words that are needed to know for the state exam. Okay, so that was the other thing I wanted to tell you about. All right, so now we're going back to estates. Actually, no, what we're gonna do, I take it back. Because we're zooming along and I don't wanna let you out too early. I'll let you out early, but not too early. So how about if we are on page 90? How about if you guys do key terms 1 and 2, all right? And then we'll go over them. Unless you've already done them. Has anybody already done them? On page 90? I guess the answer is no, so that's good. So we're going to be doing it. So let's take a few minutes to get it done. All right. Fill the blanks. This is leave.
You said page 90?
Yes, page 90. And balloons and little cups.
So this normally, when we're in person, I like pull this up on the board and we fill it in using our.
Okay. Hereditary. J. Well, that could be that. Oh, that is that. Oh, I got that. Okay. That's M. Channels. Oh. All right, let's see if that's right. Okay. We have estates in land, which is the type of ownership or the type of possession we have in real property. All right. So we can have what they call freehold estates, which means that I own it freely, 100% property. And then we have what they call less than freehold, or better termed is leasehold estates. So leasehold should tell you what that means. So what does that mean?
Leasehold?
Yes, leasehold.
That it's owned by like a bank or something?
Nope. Nope. It means that we're leasing, right? Leasehold, lease is leasing. Okay, so we have the right to possess the property, but we do not own it. Okay, freehold means I hold it freely. I own this freely. Okay, so in the state exam, they're going to be using the word less than freehold. They're not going to be using leasehold. Okay, so if you remember freehold, I own it freely. Okay, I own it freely, then you know that freehold is ownership. And if it's less than freehold, that means I'm not owning it. Okay, does that help you guys? All right, so
Yeah.
freehold is,
Quick, possibly stupid question. Freehold is still in place regardless of a mortgage, right? You own it in New Jersey regardless of a mortgage.
Right, freehold estate
Okay.
is ownership, is the act of ownership.
Gotcha.
Okay, so freehold is the act of ownership, okay? And the rights or the duration of the ownership is not determined. It's only determined by the person that owns it, okay? We're not talking about mortgages or liens or anything like that right now. So the types of ownerships in New Jersey is, and remember I told you there's like 3 or 4 different words for the same thing, and unfortunately you do have to know them or be able to understand them. So the word fee simple means that I own it 100% by myself. Okay, I own it 100% by myself. So it would also be known as fee simple or fee absolute. All right, or fee. All right. The next one is called fee determinable. So you see the word determine. Okay, so it doesn't come to make a determination. It comes from the word terminate. Okay, so fee determinable means that the ownership could be potentially terminated by something. Okay, so fee determinable is also known as fee conditional or fee defeasible. Okay, so defeasible means to defeat, termine or means to terminate. So fee determinable, fee defeasible, or conditional fee. Okay, that means that you still own it, all right, but if something happens, you may not be able to own it any further. Okay, and life estates is where you own the property, but it's based you have the right to the possession of the property and you own it, but it is based upon the life of an individual. And that individual could be the person that's living in that property, or it could be the individual that's not living on that property, a third party. Okay, and we'll go into that hopefully a little bit further here. The leasehold estates, okay, or non-freehold estates, all right, means that a non-freehold estate is for a specific period of time, okay, and a non-freehold estate is represented by a lease. So there is some sort of a lease that gives you the right to possess the property. That is really what the key is here. A non-freehold estate is you have the right of possession to that property, but not ownership. Okay? And so now we're talking about tenants on this property, and you're talking about you're owning it as personal property. Owning a lease or having a lease on a property is considered personal property because you are not owning the actual real estate. All right, any questions regarding that? So far, so good? Okay. All right, so we're back to fee simple, fee determinable, and life estate. So fee simple, okay, also known as fee simple absolute. It's the highest type of interest, which means ownership, in real estate recognized by law, okay? The holder or the owner is entitled to all of the rights. So when we're saying all of the rights, are we talking about the bundle legal of rights? Yay or nay?
Yes.
Yes, right? Okay. So if they have all of the rights to the property, that means they have the bundle of legal rights, which means we are talking about putty or putty. Okay. On the owner's death, the estate can pass to their heirs. All right. It's also known as fee simple absolute, fee absolute, any one of those versions, okay, will come up. So it just means that it's the highest form of ownership recognized by law, and it means you have all of the rights to the property. Nobody can take them away from you. Okay, I see something here. Give me a second. Somebody's. Oh, okay. All right. So now, fee determinable or fee defeasible or conditional fee. I have to put that in there. All right. So that means that the estate can terminate on a certain occurrence or a certain non-occurrence of a specified event. Okay. So if something happens or if something doesn't happen, all right, then that means that can terminate the ownership of that property. Okay, so determinable, conditional fee, or defeasible fee. Okay, and the possibility that happens now is new words here. You either have a reverter or a remainder man or a reversion or a remainder. Okay, so what happens here? So in this case here is I own a piece of property, okay, Little Silver, and this little piece of property I have dedicated to being a bird sanctuary. Mind you, I don't own it, just so you know. Anyway, and so now Johnson & Johnson owns property next door to me, and they decided that they wanted to buy my property. Why? I don't know, doesn't really matter, but they're buying my property. So my answer to them is yes, you can buy my property as long as it stays as a bird sanctuary. All right, that's the condition. All right, that is the condition that you are buying it. You're buying it, I'm letting you buy it with the condition that it remains as a bird sanctuary. All right, so 5 years from now, some family members call me up, I'm in Florida. So 5 years from now, actually, I'd rather be in California. So I'll be in California, and these people call me up, my family calls me up and they say, hey, listen, Gloria, you know, Johnson & Johnson is building a conservatory on that property that you sold them. And I go, really? Isn't that interesting? So I said, okay. So I come back to New Jersey and I call up Johnson & Johnson and I say, okay, because you have terminated the existence or the condition of the aviary, okay, or the bird sanctuary, right? This property belongs to me, okay? So obviously there's going to be lawsuits and all of that. We're not going into that. But basically the condition was you can own the property as long as it remains as a bird sanctuary. Once you change that property, then that comes back to me. So that's where reversionary or reverter means it comes back to me. You've broken the condition, and so now you're losing that particular property and it's coming back to the original owner. Okay? Are we okay with this? All right. So now we have a life estate. Okay, let's see. We do have a life estate. There it is. Okay. So the life estate is they have the right to possess and own the property as if they owned it, but it is not on paper that they are the actual possessor of the property. Okay, so I am the owner of the property. I'm letting my mom live in this particular property, and it's a life estate. It's based on her life. Okay, so she's allowed to live on this property as long as she's alive. All right, and what that means then is that she has to take care of the property as if it's her own property. She has to pay the taxes on it. She has to pay the insurance on it. She has to do everything as if she owned the property. All right, and when she dies, that property reverts back to me. So that's where we come in back again with the word reversionary interest. All right, so there's a life estate based on my mom's life with the reversionary interest that comes back to me. Okay, Now, the other kind of life estate is called, and they're going to use this in the exam, in the state exam. Be prepared. Know if it's a strange word, a Latin word, a French word, an oddity word, they will use those words. So you really need to know these words. So pour autre vie, all right, which means for the life of another. Okay, so pour autre vie, for the life of another, all right, is now based on not the person that's living on that property, but it's based on another person's life. Okay, so this example here, I let my mom live in this estate for the life of my sister. Okay, so my mom lives there, she dies, so then the remainder of that life estate, right, because my mom died, right, but it's based on my sister's life, so then my sister will get the remainder of that life estate, all right, because she's the party that the life estate is based on, all right. So when we think of tied to the life of a third party, it's the easiest way to remember is third party remainder. Okay, so life estate reversionary interest, third party remainder interest. Okay, so basically in any form of life estate, they basically own the property, but it's based on a person's life, whether it's their life that's living there or somebody else's life. So that means they have to take care of the property as if they own it. Okay, they could sell their life estate. Okay, but the problem with selling the life estate is if that person dies, then that property no longer belongs to the person that purchased it. It goes back, it reverts back to me, or it goes remainder to the third party if there's a third party involved. Okay, they can lease it, they can mortgage it, they can give it away, but again, because it's based on the life of a specific person or the life of a third party, whenever that life extinguishes, it will then go to whoever it's supposed to go to. All right. So that's very important. So the easiest way for you to remember life estate is that if it's a life estate, it's a reversionary interest. If it's based on a third party, it's a remainder interest. It's remainder man is what they call it. All right. Any questions? Okay. So we now have what they call dower and courtesy. It was set up prior to May 28th, 1980. You do need to know the date, okay? And basically what it is, the basis of it is that it is a life estate. Prior to 1980, pretty much typically, I will just say typically, okay, the properties, any properties purchased would be in the husband's name. We're going to use that as a typical situation. So the wife's name is not on there. So basically what she had was a legal life estate to the property. All right. How did she have a legal life estate? She was married to this person. All right. So she now has a life estate to this property. So if he dies, she now has the life estate to half of all of everything that he owned. Okay, automatically. That was an automatic. Anything that was purchased after 1980, dower and courtesy does no longer come into effect. Okay, and the word inchoate dower. Okay, we're talking about future interest. So if the husband and wife are married prior to 1980, she has what they call a legal life estate, okay? And she has an inchoate dower, meaning she has a future interest in that property should he die, because her name is not on there, okay? So The wife cannot convey her half, or the husband cannot convey his half without the permission of the other. So when you are talking to people, you're going out into the real world, all right, and you're going after a listing, and you notice that they purchased this property prior to 1980, all right, so therefore her name is not on the deed or not on the title, then you know that they have dower and courtesy rights, and therefore you know that she or he has to sign the listing agreement. Just because there is one name on the deed or the title, because they are married, all right, she has half of the life estate on that property. So you need to make sure that you get both signatures on that listing property. If you do not, then she has a future interest on that property by saying, I did not allow him to sell the property, therefore that property still belongs to me, or at least half of that property still belongs to me. Okay? So the bottom line, no matter what, my advice to you in the real world is when you go for a listing and you only see one name and you know that they are married, husband and wife, and that this is their main property, their primary property, you get both of their signatures on that listing agreement. I don't care what they say, all right? Because as long as they're married, this is their primary property, okay? Both parties have to sign that listing agreement, okay? If it's an investment property, we're talking about an investment property, and if it's after 1980, then whosever name is on the deed or the title is the one that's going to sign the listing agreement, all right? But anything that has to do with the marital property, all right, where they're both living, also known as familial property, you want to get both signatures, okay? Very, very important. Good? Okay, so if we had a dower and courtesy right, okay, if this couple divorces, then they become what they call tenancy by the entirety, all right? So what that then means is that it gets, let's just say for ease of explanation, that property gets split in half. They each own 50%, okay? So they each own 50% of half of that property, all right? So, I mean, 100% of the 50%. Let me rephrase it, okay? They own 100% of the 50%, okay? So that's called tenancy by the entirety. The right of possession, okay, is the dower and courtesy. Each spouse has the right of joint possession during the marriage. The property has to be occupied as a principal, matrimonial, or familial residence, okay? It cannot be released, extinguished is another word that they use, or sold without the consent of both the husband and wife unless it's a court judgment. Again, unless it's something legal that's telling you that the one has to sign and the other does not, you need to get the signature from both parties. And it's only limited during the time of their marriage. So again, if we're talking about the dower and courtesy is during the time of their marriage, but if they get divorced, then they have the tenancy by the entirety, and then that just brings it up to date. Okay? All right, so that's that. All right, moving along. Right, okay. So the word encumbrances, that's a word that they use a lot, all right? My definition of encumbrances, to make it easier to understand, is called obstructions. What is stopping me from getting something, okay? So an encumbrance can be stopping me from getting something, all right? An encumbrance could be what they call a lien, or it could be a charge, or it could be some sort of liability that's attached to the property and it's binding the property, meaning that until this encumbrance is taken care of, I can't sell this property. This property cannot be transferred, okay? So an encumbrance can limit the use of the property, it can limit the value of the property, and it can also limit the title of the property. So one of the main ways that a property is limited is when we have a lien, all right? And a lien in nowadays language would be a mortgage, okay? So a mortgage is considered a lien in New Jersey, all right? A judgment can be an encumbrance. You didn't pay, you had somebody come out and fix your house, do all sorts of things. You didn't pay them, so they went to court and they got a judgment against you. So you have a judgment lien against you. So now until the judgment is paid off, you can't sell the house. You can't sell the house if you can't pay the mortgage. So that's what a lien is, okay? A physical or a usage encumbrance can be, there's been a restriction put on the property. You have an easement on the property, okay? You can have a license on the property, or there could be an encroachment, all right? So let's start with liens. So liens are a financial claim, all right? And this financial claim means that this property has been put up as a security to get monies, okay? So we have a voluntary lien, we have an involuntary lien. We have general liens and we have specific liens, okay? Ugh. All right, God, I hate this thing. All right, so a voluntary lien, there's only two kinds of voluntary liens. It's either a mortgage or a bond. So the only way that I would have a bond is my sister went into jail and I posted bond for her, so I put my house up for security to get her out of jail, all right? Those are the only two voluntary liens. Everything else is involuntary, okay? Now, voluntary liens, because it's a mortgage or a bond, are specific liens, all right? Because they belong to that one piece of property that I own. Okay, so a voluntary lien, there's only two. It's a bond or a mortgage, and it's a specific lien because it's regarding the property that I put up as collateral, whether it's collateral for a mortgage or collateral as a bond, all right? An involuntary lien is somebody put a lien on my property and I did not allow it. Now, there could be different types. There could be a lien, like I said, a judgment lien, all right? Or a construction lien or a mechanics lien, or it could be a tax lien, all right? So with an involuntary lien, it could be a specific lien that is involuntary. So a tax would be considered, a real estate tax is a lien, and it would be considered involuntary and specific. Right? Because I'm paying real estate taxes on a specific property. So that is an involuntary lien. So a real estate tax is an involuntary lien on a specific property. You can have a judgment or a construction lien, okay? That is an involuntary lien, all right? And it's placed on a specific property, okay? A general lien can be a, what do they have here? What is that? All right. Usually a general lien happens when I'm a roofer, okay? And I did work on this person's house, and I know that they own several properties. So in order for me to get paid, I don't want to just put a specific involuntary lien on the house that I worked on. I want to be able to put a specific lien on each of their houses that they own, so that if they decide to sell one of their other houses, I am going to get paid. So that is a general lien because it's going on all of the houses that they own. All right, so that's a general lien that's going to attach to all of their houses that they own, and it may attach to some personal stuff that they have as well. So a general lien will be on real estate property, and it can also be on personal property. Okay, so that's a general lien. Okay. And it's also an involuntary lien, okay? Let's see what else. A vendor's lien is a seller that did not, a vendor is a seller that did not pass the title. Wait, is that it's backwards. That's backwards, hold on. Okay, a vendor's lien is a seller's lien and they didn't get paid. That's what it is. A vendor's lien is a seller's lien, okay, and they didn't get paid by the buyer. A vendee's lien, okay, is a buyer's lien on the seller because they didn't get title to the property. Okay, so at this point in time, we need to go over the E's and Or's. All right, so let me pull that up for you guys. Escape, right? And then let's go into Classroom. No, that's YouTube. I don't need that right now. All right. So are you seeing my screen, what I'm doing here?
Yeah.
Oh, okay. All right, good. All right. So then I can just pull it up. Drive. All right, school. Let's go E's. E's. All right. So here are the E's and Or's. I know I have it in Google Classroom. It's going to spit out. So I'll just let you know. We'll start out here. So the E's and Or's. The OR, the easiest way to remember is that you own whatever it is that you're talking about. So if I am a grantor, okay, that means I am owning what it is. So in this case, I am the seller. As a grantor, I am a seller, okay? As a grantee, I am receiving, so therefore I am the buyer. So if we're talking about a sale here, I'm selling the property, so I am the grantor. You guys are the buyers. You are receiving my property, therefore you are the grantee, okay? So a vendor is the seller, I own it, and the vendee is the buyer, they're receiving it, okay? And then we can go down the line here. So if we have an assignor, that means we're making an assignment and the receiver is the assignee. If we're talking about issuance of a license, so the real estate department is the licensor and the broker salesperson is the licensee because you are receiving that license, okay? Trustor and trustee. So again, when you're owning it, so for me, the easiest to remember was OR means I own it and EE means I'm receiving it. All right, that's the easiest way. This will come up. The biggest problem word that most everybody, inclusive of seasoned real estate agents, is mortgage or and mortgage E. All right, so mortgage or is the owner of the property that's pledging it to get monies. So if I'm buying a piece of property, right? And I'm pledging the property so I can get a mortgage. I am the mortgagor, all right? And the bank is the mortgagee because they're going to be receiving monies from me on a monthly basis, if that's easier to remember, okay? The offeror and the offeree, again, it's the same thing, but here we'll be talking about it in a different situation. The leaseor is the landlord, and the leasee is the tenant. So they're receiving the property. The leaseor is putting their property up for lease, and the leasee is the one that's receiving the property to be able to live there. Okay, so that's a good start there. Are we good? Yep. All right. All right. So we're back to chapter 6. What? Okay. All right. So that's basics on liens. Okay. So what can these? So let me go back here for a moment on liens again. We're back to here again. All right. So when we have a lien, okay, as I stated before, everything has to be in writing, and now everything has to be recorded in order for it to be legal. In order for me to prove that I am owed whatever it is that I am owed, I need to be able to record it. So typically, I will be recording this where in the county that the property is in. So if I am the roofer and this person has several properties in different counties, I am going to have to do my general lien on these properties in the different counties where the properties are. So wherever the property is located, whatever county the property is located, that is where everything has to be recorded, okay? So if you own property in Monmouth County, then you are recorded in Freehold at the Hall of Records. If you're in Ocean County, I believe it's Toms River is the county seat, and that's where everything is recorded for all Ocean County properties, okay? So now why would I be wanting to record it? Well, there's several reasons. The reason I would want to record it is, I want to prove that that scumbag owes me money, all right? But secondly, I want to make sure that if there's any other people out there that this scumbag didn't pay, that I am in first position so that this way I can get paid before all the other scumbags get paid or the other people get paid, all right? So the key here is you're talking about priority, the recording of priorities, all right? So tax liens are always priority number 1. No matter who you are, what you are, doesn't really matter. Tax liens are always paid first, and they're always in first position. The next position, which again is the most important position, is the mortgage company or the bank, the mortgage bank. All right, they are always in first position. We don't discuss tax liens because we know that that's priority over everything. So if we have a property that has a mortgage on it, then they're always in first position. And anyone else that comes in after that is then now in secondary, third, and fourth, and fifth position. So when I go up there because the scumbag didn't pay me, all right, I want to make sure that I'm as top position as I can be. I'll never be above the mortgage, but I will be above all the other construction liens that might be coming in if they record after me. Now, there might have been somebody that recorded a construction lien ahead of me, so I will be based on the day and time that I'm recording my lien is what my position is. So sometimes recording can come down to as finite and detailed as the timing of that particular recording. All right, so you always want to record whatever it is you're going after. All right, and that again, a lien is considered an encumbrance. All right, so what can effects of the liens do on a title? all right, or what can happen with them. So the liens basically attach to the property. They do not attach to the owner, okay? The priority of liens, as I mentioned, is tax liens are priority or over all the other liens, okay? And then anything else after that is determined on the date of recording. Okay. All right, so we would have mortgage liens, construction liens, judgments, and any other kind of liens. And depending on when they were recorded is the determination of how they would get paid, okay? Okay, and let me just see the book here, because, all right, so that's basically that. All right, so we're doing judgments. Okay, judgments, the key word that you need to know, I'm gonna have to redo this again. All right, so judgments is a decree by the court. Okay, so the word decree is what you need to know. All right, and then you need to know that, where is it down here? Okay, you need to know the word satisfaction piece, satisfaction of judgment or satisfaction piece, all right? And what that means is, and that has to be recorded, because if you've paid off the judgment, you want to make sure that you get a satisfaction of judgment showing that you paid off that judgment. If you have a mortgage and you paid off the mortgage, you want to have a satisfaction piece of mortgage that it was paid off. Because if it's not, if that neither of those are recorded, then as far as the records and the rest of the world, they still think you owe people monies. All right. So satisfaction piece or satisfaction of judgment is what shows the world, because again, it's being recorded. It shows the world that it has been paid off, all right? And also when you're doing refinancing, you want to make sure that when you refinance, that you get a satisfaction piece showing that the original loan is paid off and now we have a new loan because we refinanced it, all right? The other kind of loans that we can have is IRS loans, and that's basically a tax lien. It's a general tax lien because it's a federal, and so federal tax liens are general, and therefore they will be attached to real estate and personal property. So when you hear the FBI busted people and they say that they took the cars, the real estate, the Rolex watches, and all of that, that is a general lien because it's a federal tax lien. All right, so that's where, so therefore it's a general lien, of course involuntary. So how do we know that there's something legally going on with the property? Well, the way we know that is through what they call a lis pendens. All right, so a lis pendens is basically an alarm saying beep, 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 beep. Hello, people. There's something going on legally with this property. We're not quite sure what it is yet, but there's something legal happening. So we're just letting you know that you might have to dig deeper. Okay? So if you have, if an owner has not paid their mortgage for 3 months, right? They've missed 3 months mortgage payments, the bank will automatically put up a lis pendens on that property. All right. So basically, it's basically saying that beep, 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 something happened here. They're not telling you that they didn't make a payment or they didn't do. They're just saying that there's some legal issues happening with this particular property. All right. And it's telling us that we need to dig deeper to find out what exactly it is that's going on. Okay. So that's regarding lis pendens. What it also does, let me back up here. Any of these items here could potentially put what they call a cloud on the title. All right. So what does that mean? It means we have an obstruction on the title. All right. And therefore we cannot pass title or ownership of that title to, let's say, a buyer until all of these obstructions have been taken care of. Okay. So a lis pendens can also be a cloud on the title because there's something legal happening on this property that until this legality issue is taken care of, we cannot pass clear title to whoever it is that we're going to be passing it to. All right. So it's called a cloud on the title. All right. Now we can have, like I said, we can have tax liens and a mortgage, and we're putting the house up for sale. Well, we know that if we're putting the house up for sale, we know that when we get paid, that the mortgage is going to get paid and the taxes are going to get paid. So therefore, that cloud on the title, based on that, is not going to hurt. It's not going to be an obstruction that cannot be taken away, because it will be paid off once we get the money from the buyer. All right. What cannot be taken away, or what cannot be paid off, let's just say, could be a judgment. If there's not sufficient monies from the sale of the property and there are judgments, then in that case, until those judgments are paid off, we're not going to be able to give clear title. So if there's not sufficient monies from the purchase or the sale of the property, then that homeowner is going to have to pay it off before they can continue to finish selling that property. Are we good? Yep. Okay. So the next thing that we have to talk about, oh good, it's there. All right, so the next thing that we have to talk about is easements. Now, an easement can be an encumbrance on the property, but this encumbrance can actually travel with the property. So what it is, an easement is the right to go on someone else's property for a specific purpose, okay? So if you look at your page 99, which this is the picture here, okay? So if you're looking at this picture here, we have several encumbrances and several issues. So the first one here is called easement appurtenant, okay? Appurtenant means next to, adjacent. So in this case here, this house has an easement appurtenant because they want access to the lake, all right? So these properties are side by side. So we have lot A and we have lot B. So an easement appurtenant is because they're next door to each other and he wants to access the lake. So that's an easement appurtenant. Okay. Now lot A has a house, and as you can see, there's a forest in front here. There's no driveway. There's no way for this person to access this house. All right. So this property, lot B, gave them an easement by necessity to travel over his property so that they can access their house. All right. So in this case, lot A would be considered landlocked, all right? Because there's only land, there's no way for me to get to this house. So I need to get an easement. So lot B says, okay, fine, I'll give you an easement on my property so that you can access your house. And the only reason is because it's a necessity that you have to access this house. All right. So what happens here is as follows. Lot B is the servient tenant. They call it tenement or estate. Let's call it estate. The servient estate to lot A. Okay. And lot A is the dominant estate. All right, and so the easiest way to remember is that the estate, the person, whatever word you want to use, that is benefiting from the easement is the dominant person. The person that is servicing the other person is the servant. So therefore, they're the servient estate. So in this case here, Lot A is benefiting from the easement that Lot B gave them. All right, so Lot A is the dominant estate and Lot B is the servient estate. Okay, so now let's just say Lot B decided to buy Lot A. Okay, so now we've merged, there's one owner for these two pieces of property. Okay, so the easement appurtenant that he had to access the lake automatically disappears. All right, because now they're owned by one and the same person. What? Okay, so, but if he's renting out the house, okay, there's still that easement by necessity to access this house here. So that does not go away. So an easement appurtenant, which means an adjacent property, once it's taken over by one owner, that gets merged and the easement appurtenant goes away. But this particular easement, the easement by necessity, does not go away because they still need this easement to access this house. But there is no benefit, there is no dominant or servient because it's one person that owns that property. Are we good with that? Yeah?
Mhm.
All right. So the last kind of easement that we have is what they call an one of the last easements, is the easement in gross. And what that is typically, it is a utility easement, all right? And so basically what it is, it allows the utility companies, phone company, water company, electric company, cable company, or whatever, to go on this property in order to maintain whatever it is, the utilities they have there. Okay, so that is an easement in gross. Now, the key with an easement in gross is that if I own this property, Lot B here, and I own it all the way to back here, all right, I am not going to be able to fence it off. Okay, because this theoretically belongs to the utility people. So I would be able to fence it off. If you see my arrow here, I'd be able to fence it off here. Okay, I cannot fence off an easement in gross. I can use it. So if I don't want to have a fencing and I want to make it look like it's a green all the way through, I can just leave it open and I can use it, but I cannot, what was going on here? All right, but I cannot put any permanent structures on the easement in gross. Okay, so I can use it as long as I don't waste it, I don't do something bad to it, but I cannot put any structures on there. So like, for an example, I could not put a shed in that little section there that's sitting on top of the easement in gross. All right, I can put it on my property, but I cannot put it on there. All right, so let's go back here. So easements, whoops, get back here. So an easement appurtenant is an adjacent easement, okay? If the adjacent property is purchased by the one owner, then the easement appurtenant goes away because it's now merged into one property. An easement in gross is where the utilities have the right to go on that property and to maintain that property. An easement in necessity is because the property is landlocked and they need access to that particular property. So an easement in prescription, all right? So for me to explain it to you is just remember these words, all right? If you remember these words, you'll know exactly what they're talking about when they ask you the question. So the key words to remember, let's see if I have it here. No. Okay, so the key words is continuous, hostile, open, notorious, uninterrupted. Okay, that's on page 100. And that should be, that's in the middle where the bold word tacking is. So if you see the words continuous, uninterrupted, what did I say? Hostile,
Notorious.
notorious, thank you, notorious. Thank you for helping me. Any of those words, you know they're talking about an easement by prescription. So let me give you my example about the easement by prescription. There's a school right to my right, and then there's a house, and then on the other side is a candy store. And the kids at lunchtime and at break time and whenever time, they cross over this person's property to get to the candy store. And they've been doing this back and forth for 20 years, okay? So it's been open and they're going back and forth and back and forth and back and forth. So potentially the school could go for an easement by prescription on that particular property so that they theoretically own that property because the kids are going back and forth, back and forth. So that's the easiest way to remember, other than the words that I told you. Now, if that owner of that property had told the kids, given them permission to go on that property, then there's nothing. They've gotten permission, they're allowed to go on that property, and it's no big deal. The key to the easement by prescription is that it has to be open, notorious, hostile, continuous, no permission, and it has to go on for 20 years before the school could go and go to court and ask for an easement by prescription. Now, it could also be tacked on by additional generations, so if it goes beyond 20 years, it could be 30 years if they do that, or 40 years, as long as there's been this continuous hostile open use of this particular property. The moment that that particular owner tells the people, yes, you're okay to go on my property, and let's say we were at year 19, right? The time stops. And now we start from year 1. Okay? If we continue to do that. The moment the person says you can get on my property, that easement by prescription time frame goes away. There's no more time frame. Okay? So the key to remember here is that it's 20 years, okay, to get an easement by prescription. It's notorious, continuous, hostile, okay? And we can tack on through successive generations additional years if we need to, all right? And it is a legal action, so it has to go in front of the court, okay? So that's an easement by prescription. A party wall is basically when there's a wall that is being used by 2 parties. In this case, a good example would be a commercial building in one of the older towns where you have the walls that are shared by 2 different buildings, 2 different property, 2 different businesses, okay? So they each share one wall, right? So that would be a party wall. So both parties have to maintain each side of that wall. Or there's a wall on a property, instead of a fence, it's a wall, then that would be considered a party wall, and both parties have to maintain either side. The other kind of a party wall would also be considered a shared driveway. Like in Bradley Beach, there's a lot of houses that have a shared driveway, so you go down the driveway, but then you separate to go to your individual garage, all right? So that shared driveway could be considered as well a party wall, depending on how it was set up. If it was set up as a party wall, then basically that middle line is what you're responsible for. But if it was set up as an easement on one property, so again, if it's set up with an easement on one property, what would we potentially have?
Yeah, one more time.
Okay, if we had an easement that was set up legally to attach to one property, what would we potentially be having? Where's that picture?
That the easement opportunity.
No, it would not be that. Here I am. So here's the shared driveway, right? And we've attached it to lot B. It's a shared driveway, right? So we've attached it to lot B. So therefore lot A becomes what?
Easement by necessity.
Yes, but that's not where I'm going for.
Is that like the
Like
dominant?
subservient or dominant?
Dominant and servient, that's exactly what I'm going after. Yes,
Okay.
right? That's exactly what I'm going after. So the one property would be a dominant property and the other person would be the servient property, okay? Or if they are sharing the easement and it's down the middle of the sharing the driveway, and then the middle line becomes a party wall. So that means each side has to take care of their driveway, right? Not that there's a physical wall there, but they have to take care of each side of the driveway. Depends on how it's set up. Now, again, like I said, Bradley Beach, they have shared driveways, and sometimes you just don't know whether it's an easement attached to one property, or is it considered a party wall. So those are things that one has to find out. Okay, so we did that. Okay, where am I? Okay, so that's that. So creating an easement has to be in writing, as with everything else. Okay, so creating an easement, there's got to be an express grant, meaning we're allowing the person to put an easement, or we're allowing the person to have an easement. We have a grantor, again, the one main person, all right, is reserving the easement on their property. There could also be a creation of easement that has been going on for forever. So as an example in the picture, let's play pretend. If I find the picture again, I lose it. Doesn't matter. All right. Oh, there it is. So let's play pretend that there's several properties here, and there's these cows that live here. And so these cows are hopping along while they're walking over here because they want to go drink water from the lake. All right. So there was never really a written easement about these cows going over these people's property, but it's been going on forever and ever and ever, and it's just been granted that these cows are going over there. All right. So we have this easement and everybody knows it. All right. So it's a knowledge. It's a known fact, or it's not something that's hidden. So how does that easement finish? Well, this farmer sold off the farm, so there's no more cows. So therefore now the usage of this easement is no longer in place. So this particular easement has been terminated due to no longer being used, okay? The original easement was a usage easement because the cows were walking back and forth to get a drink of water, okay? We have the easement by necessity. So again, because we're landlocked here, so we have an easement by necessity. So we wrote that up. We have an easement appurtenant because again, I want access to the lake. This lot is owned by a different person. So again, we wrote up an easement appurtenant so that I can access the lake. But if I chose to purchase lot A, then this easement appurtenant goes away because the two lots have been merged into one ownership. What was the other thing that I wanted to say? That's it. Now, again, the easements always go with the land. So if we have an easement by necessity and lot B is selling their property, then this easement goes with the sale of the land. Okay, so easements go with the sale of the land. That was the other thing I wanted to talk about. Okay, Again, terminating an easement could be because we're no longer using it, the cows are no longer there, or in this case here, Lot A decided to build a driveway here and go in through their own property, so the easement by necessity is no longer there. Obviously, it's got to get terminated legally and in writing, but that's how we can terminate that easement, okay? Because we now have a new driveway going into there, and that's it. That's all that I can think of on that one. So that's terminating an easement. All right. But if there is an easement, it goes with the land. It runs. The phrase that goes is, it's called runs with the land. The easement runs with the land. Okay. All right. A license. Okay. So not the kind of license that you guys are going after. It's a permission. All right. Or it's a privilege. It's not necessarily in writing. Okay. And it's not forever. So it's basically you're allowing somebody to come onto your property for a particular reason, all right? So again, landscapers, you're allowing the landscaper to come and do your landscaping. Now you may have a contract with that person. So obviously if you have a contract with that person, you have, it's a contractual agreement. But if you have somebody that's coming to do your landscaping and it's not in writing, you're giving them a license to come on your property. You're giving them a license if you have kids and you're having the babysitter come over to your house to take care of kids, or a cat sitter, dog sitter, dog walker. All right, that's a license. So it can be in writing, it can be spoken, all right, but it's not permanent. You can take it away from them at any point in time. That's the key on that one. Encroachments is when something is on top of your land without your permission, okay? A typical encroachment could be a fence or a driveway, or it could even be a building, or it could be a deck, or it could be a patio, okay? Basically what it is it's extending illegally onto your property. And usually the reason is because that other person never looked at the survey of their property, okay? And so they just said, okay, yeah, this looks like the place to put it, so let's put the fence here, and that's that, okay? And usually it will be discovered, typically it's discovered by a survey, because that's the most accurate way to find out where your property lines are. But again, if it's really overstepping it, then you can physically see it, all right? So that is called an encroachment, okay? Right. Now, a deed restriction, all right, remember we talked about fee determinable or fee defeasible or conditional fee, right? It was a condition that was attached to the ownership of that property. And if that condition was broken, then that could revert or remainder back to a person, correct? Okay. A deed restriction is a restriction on the property. It is done by a private person, but it only restricts the use or the look. So my example for a deed restriction is I was representing this builder, and he put up 15 houses, and he designated in the master plan that all of the houses have to be black. And that is the deed restriction. So the restriction is all of the houses have to be black, all right? And I go and I buy a house in this development, and I don't like black houses. So I decided to paint my house red. And the realtor that sold me the house never told me about this deed restriction. Terrible realtor. And didn't give me the bylaws and the covenants and all of that. So I had no clue that there was a deed restriction on this property, on this house. So all of a sudden, a bunch of neighbors come knocking on my door, and they go, hey, listen, I see you painted your house red. Did you know that there's a deed restriction? And I go, no, I didn't know that. Well, you should have read it. And I go, yeah, well, my realtor should have given it to me or made sure that I got it. But bottom line is you have to paint the house back to being black because that's the restriction. And if you don't like it, then you can sell it. But we can enforce it by going to court. All right. So I am not losing my property. That's the difference. But I am forced to comply to that restriction. Okay. So the restriction is that it has to be black. I painted it red. The neighbors came to me. They said, if you don't paint it back to black, we can enforce the restriction. It's just a rule. Okay, it's not a condition. It's just a rule. And the rule is all houses have to be black. All right. Are we understanding the difference between fee defeasible, conditional fee, and a deed restriction? Another type of deed restriction would be where the condominiums restrict having pets. Okay, I'm not going to lose my house. I'm not going to lose my condo if I bring a pet there. I'll lose my pet, but I won't lose my house. Okay, with a pet restriction. Okay, and a pet restriction is a deed restriction. Okay, all right. Look at that. It's 8 o'clock. So we're done with that. All right, so now I just want to make sure I got everything that I was supposed to get to you guys. Let me just go over the words. Let's see what the words are that we have in the front here. Okay, so construction lien is somebody that didn't get paid by the owner. And so they're going to go record their judgment against that owner. So that could potentially be a specific lien, or it could potentially be a general lien because they're going after all of the properties that that person owns. To convey means to transfer, okay, or to give to somebody. Courtesy in this case is the life estate, okay. Dominant estate is the person that is, it's the estate that is benefiting from the easement, all right. The dower is the female version. Courtesy is the male version of a legal life estate. An easement is the right to go on someone's property. An easement appurtenant is the right to access another person's property as long as they're adjacent to one another. An easement by necessity is because they are landlocked, and so they need to be able to access their property. An easement by prescription is notorious, continuous, hostile. An easement in gross is a utility easement. An encroachment is when somebody's overstepping their boundaries. An encumbrance, so let me ask you, are all encumbrances liens?
No.
No,
No.
no, because an easement is an encumbrance. Okay, so an encumbrance can be a lien or it could be, Meowster. Okay, here. Come on, right there. Okay, so an encumbrance can be a lien or an easement, okay? Fee determinable, we said that it's a condition. A condition has to be broken, and if the condition is broken, then that means there's going to be a reverter or a remainder man involved in it. All right, that's fee determinable. Fee simple is the 100 absolute highest and best way to own a piece of property. Okay, a freehold estate means I freely and 100% own the property. A general lien is basically, if you were to talk about the FBI or the federal tax liens, that goes against property, all properties, and could be inclusive of personal property. An involuntary lien would typically be a tax lien, a judgment, a mechanics or construction lien. I didn't allow them to put this lien on my property. A leasehold estate, or is also known as a non-freehold estate, and that basically means that I have the right to the possession of the property, but I do not own the property. So I have the right to a possession. A license is a privilege to go onto somebody's property. It's not forever. A lien is basically I'm letting the world know that I owe somebody some monies, and they're using my property as collateral, or I'm using my property as collateral. A life estate is basically I own the property for as long as I live, or I own the property for as long as someone else's life, based on somebody else's life. And a life estate is recorded. It is a recordation, but you're not the actual owner of the property. A lis pendens is basically a legal notice that there's something legally happening here, Master. Okay, a mortgage lien means that I borrowed money and I put my property up for security so that I can purchase it. A party wall is basically shared by two side-by-side properties, and we both have to take care of it. Priority is basically when was whatever it was we're talking about, when was it recorded, and compared to others, am I above them or below them? The remainder man is based on pour autre vie, or for the life of another. So the easiest way to remember remainder man, third party remainder man, okay? Life estate reversion. Okay, so life estate reverts, life estate reversion, third party remainder based on the life of a third party. Reversionary interest means it comes back to me, okay? Servient estate is the one that has the easement on their property and helping another property access theirs. A specific lien is specifically to a particular parcel of property. Tacking is when we're adding on additional years to get a easement by prescription. All right, we're adding on additional years. And then a voluntary lien typically is a mortgage or a bond because I want to get my sister out of jail. All right, are we good? Yeah? All right,
Yeah.
so, okay, so you guys are gonna do key terms 1 and key terms 2. Not now, well, you can do it after you hang up with me. So we're going to be doing, on Tuesday, we're going to be doing chapter 3, agency.